The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, everyone. My name is Pam Mazza, and with me is my colleague, Paul Mengel. Thank you very much for dialing into our webinar today called Avoiding Litigation. And today is part of a series. Today we're going to focus on protecting your prime contractor, subcontractor, or other strategic relationships. And what Paul and I have done is we have gone through some provisions of subcontracts and teaming agreements to pick out the ones that we have seen most recently either be the subject of full-out litigation or the subject of disputes or questions from clients in terms of how do you interpret this clause and what is the meaning given a particular situation once the contract is already up and running. So we chose those clauses to go through and focus on. There are lots of other important clauses in subcontracts, and obviously they can be discussed. If you have any questions or any thoughts during this webinar, please write them in. You can see a box on your screen, I hope, to put questions up, and we will try to answer as many as we can as we go along. And if we get behind and can't answer particular questions, we will shoot you an email response shortly after the webinar's conclusion. If you're not on our mailing list, please review this slide because it will tell you how to make sure that you are on our mailing list to give you our Legal Advisor newsletter, our PM Legal Minute, and weekly updates, and then more information about webinars. All right, let's get started. The first topic is negotiating a definitive work share clause. And of course, this sounds like it would be easy just if you read this language, but as I'm sure many of you know on the phone, it isn't an easy task at all, particularly in today's environment with multiple award contracts and IDIQ type contracts. The first time that you need to consider what work you will be performing under a particular opportunity is very, very early on if you are, doing your planning properly in the teaming agreement stage. And deciding who will do what or what the percentage of work is that each party will perform at this stage is sometimes very difficult. You may not see the statement of work. You may not have a draft. The solicitation is likely not even on the street yet. Yet it's extremely important that you try to nail down as many terms and conditions as you possibly can as you're moving through and reading, drafting, and negotiating your teaming agreement. We've had a recent case from last year, and this was a Fourth Circuit ruling regarding teaming agreements, and Paul's going to discuss this case now.
Good afternoon, everybody. The case that Pam referred to originated in the Eastern District of Virginia, which some of you may know of as the Rocket Docket, but the Eastern District, in as much as it encompasses the technology corridor and large swaths of Northern Virginia, gets a lot of government contracting cases, and they are resolved very quickly. In this particular case, incidentally, there was a blog entry on our website that discusses teaming agreements and form teaming agreements in more detail, where there's an analysis of this case. But the CyberLock case, which was entitled CyberLock Consulting Inc. versus Information Experts Inc., and we can give you the citation to the case and more information if you want to shoot us a line, if you would care to read it in your spare time. That case really sent ripples through the government contracting world, and even has resulted in some folks reconsidering whether they want to choose Virginia as a jurisdiction for dispute resolution. In that case, involved a teaming agreement that the court was called upon to decide whether the teaming agreement was an enforceable contract or merely what they call an agreement to agree in the future. And I would say that generally speaking in Virginia, teaming agreements and in a lot of jurisdictions are scrutinized very closely because the more contingencies they have built into them, the less likely there to be a definitive agreement and more an agreement to agree in the future, which is not enforceable. In this particular teaming agreement, the percentages of work that each party was going to perform upon award was set forth, and there was an exhibit that spelled out the anticipated scope of work attached to the teaming agreement. It did not, however, include a proposed subcontract, and it had language in the teaming agreement that included a lot of contingency. For example, if they did not enter into an agreement after good faith negotiations, the teaming agreement would terminate, etc. The CyberLock court looked closely at the agreement and noted that the language in the agreement that said that there was a possibility that a future transaction might not come to pass, references with such terms as anticipated, and the lack of an attached subcontract with specific terms resulted in the court deeming it to be an unenforceable agreement to agree. And you can imagine that the disappointment to the party that brought the litigation. So what do you do in light of CyberLock? I think one of some general guidelines in terms of trying to make a teaming agreement an enforceable agreement as opposed to an agreement to agree are to be clear and concise about the purpose of the teaming agreement, to make it mandatory, not an optional, that the prime contractor shall enter a subcontract with the sub, put as much detail about the proposed subcontract as possible in the teaming agreement, and attach a copy of the subcontractor's exhibit. You should avoid, to the extent you can, possibly avoid listing outs, that is, events that will trigger the termination of the teaming agreement, and you should put an exclusive arrangement in there such that the parties go forward together or not at all, and put as many, generally speaking, as many specifics about key provisions as you can, such as scope of work, confidentiality provisions, duration, allocation of costs, intellectual property, price, place of performance, choice of law, dispute resolution, etc. The more terms such as that you have in one of these agreements, the more likely it is to be deemed an enforceable agreement as opposed to an agreement to agree in the future.
Thanks, Paul. And as Paul said at the beginning of the case, teaming agreements and subcontracts as well are governed by state law. And they're governed by state law oftentimes that's designated under the terms of the teaming agreement or the subcontract. If the agreement itself doesn't say what law applies, then you're going to have a fight maybe about that, including the jurisdiction of what court and in what state you are.
And that's right. And Pam, if I may, that leads to a very good point, which is everyone knows how expensive litigation is. And if nothing else, you're going to expend funds fighting about ambiguous terms. And, for example, if you had been the drafter of the contract and the terms are ambiguous, those terms are going to be construed against you as the drafter. So there are so many reasons to be as specific as possible. And as Pam mentioned, in terms of choice of law, some jurisdictions allow what they call a blue pencil rule, where provisions will be rewritten by a court if they believe them to be unenforceable, whereas in, for example, Virginia, if the provision is too broad, then the court's simply going to strike it, and there's no chance to have it rewritten. So you really need to consider on the front end, A, what jurisdictions have the substantive law that's favorable to your position, and B, what sort of convenience for jurisdiction and courts, and the way the courts have the track record of the courts in resolving these kind of disputes is critical.
Now, so being as specific as possible is obviously important, and it's extremely critical if you're in the Fourth Circuit and specifically in Virginia. But that may not be practical. So then the question is, all right, let's back it up and say that we have a teaming agreement that we know may be lacking in critical terms because we just don't know enough about the opportunity yet. Does that mean that you shouldn't sign a teaming agreement? I don't think so. I think that we don't go into situations assuming that we're going to end up in litigation. So the primary purpose of a teaming agreement is to have a meeting of the minds at the outset by the parties so that there is no misunderstanding down the road. So a teaming agreement is still a very, very useful exercise no matter where you are in terms of ensuring that you understand and that your teaming partner understands the expectations. So try to be as specific as possible and nail down as much as you can. We always know what the proprietary information clause should be. We know what the opportunity is that we're seeking. We know what the purpose is. We should know who the prime contractor is, who the subcontractor is. So nail down as much as you can nail down, and the ones that are still a little bit loose, try to have as specific as you can. So let's turn back now to the actual language of the teaming agreement. And as Paul was speaking, I thought, I'm thinking back to many, many teaming agreements that we've reviewed, and many of them contain those very same terms. You want to have an out if the solicitation hasn't hit the street in a year. You want to have certain outs to be able to terminate the teaming agreement. And if you can't negotiate in good faith and get a subcontract after award and the procuring agency has squeezed you in price, what do you do? So, I don't know that we have good answers, but I think there are just thoughtful questions that need to become more and more a consideration as you are drafting and negotiating these teaming agreements. So back to our standard teaming agreements, where do we put the most important term, which is how much work do I get? We put it in Exhibit A. So the Exhibit A percentage of work has been in the past something that people have struggled with. And again, under the terms of the case, we should struggle even more to try to be as definitive as possible. Obviously, you drill down on this again in the subcontract. But in the teaming agreement, go by what you know. Is there a percentage of work that each party expects? Do you expect to perform 50% of the work? Do you expect to perform certain labor categories or certain CLINs? Or can you define that in another way, that you would perform all of the systems integration work and XYZ performs all of the data processing, or in some way so that you can argue later that there's a formula, at least in Exhibit A, that is not subjective, and that once you have the definitized contract, you can take that contract and plug it into Exhibit A, and that's the agreement that you've reached. So that's one suggestion that we have for trying to be specific in Exhibit A. If we move on to subcontracts. So you have your teaming agreement, and that is supposed to govern until you have a signed subcontract. Now, obviously, as the court suggested, if you can draft your subcontract and have it as an attachment to the teaming agreement, that's great. I don't know that you would have it signed until you actually have a contract award in hand. But once that subcontract is being negotiated, again, you need that meeting of the minds and written detail in terms of what the breakdown of work is. Now, how do you address it if you have just received a multi-award task order type contract? Not so easy, and it depends on how many other subcontractors there are, what the variety of work is. But again, if you're a subcontractor and you think that you were promised a certain percentage of any particular type of work that is going to be awarded under the contract, then you need to have that reduced to writing.
Well, and one of the, as you see on the slide, the meeting of the minds and the avoidance of future disputes, the more clarity you have, obviously, and this is common sense, the less wriggle room there is for one party to assert that there is some sort of ambiguity or vagueness in the agreement. Because believe me, again, with the cost of litigation being such as they are, the last thing you want to do is to have an ambiguous contract being determined by someone in a black robe who doesn't really care one way or the other about who gets a resolution in their favor. It's an expensive process to have a court decide. As I mentioned earlier, if you were the drafter of the document and it's deemed by the court to be ambiguous, then any ambiguity is going to be construed against you as the drafter. And again, as the slide indicates, with clarity, and if there's no dispute with regard to the resolution of that particular issue, you've saved yourself a lot of funds. So it's critical to have the detail, the meeting of the minds, and that documented so that you don't have some arbitrary third party deciding what could be potentially millions of dollars worth of disputes against you because you didn't take the time to draft these documents with clarity and precision and to get all the details in the documents you possibly could.
Another thing to think about is whether or not, if you're in the role of a subcontractor, what type of information did you give to the prime to pass on to the government in the proposal stage? And at best, I think that you could use that as some sort of a standard for determining, what your rates are, what your pricing is, and what the amount of work is that you would be doing, or at least the type of work that you would be doing were your team to win that award.
And certainly that would be used as evidence. If the document wasn't clear, then when the court is going to look to what did the parties agree to, if they think that the contract is somehow ambiguous, they will look to extraneous documents that are outside the contract. And as Pam indicated, if you've passed through a document that has those percentages set out, or if you have other memorialization of what you intended at the time, then if the contract is unclear, the court will look to those outside information to determine what the party's intention was when they were discussing the agreement.
And before we move on to escrow agreements, there's a question as to whether or not, if I'm a subcontractor, do I want a teaming agreement and a subcontract, or should I just go to a subcontract? And obviously, it may be hard to just simply negotiate a subcontract up front, but if you know enough and you can be definitive enough, then it would be great to have that subcontract. Most of the time what we see, though, is that you have a teaming agreement, and that teaming agreement's done at a point in time when you don't have enough terms to know about the subcontract. There's also things in a teaming agreement that govern the relationship of the parties during proposal preparation. So, for example, there's confidentiality provisions in a teaming agreement. If you don't have a teaming agreement, then you should have a separate non-disclosure agreement at that point. There are also things in there about which parties are paying. Usually the parties share in the cost. Is there exclusivity? Are you being told that you shouldn't be on multiple teams, or is that acceptable? So there are parameters in teaming agreements that get dropped out before you negotiate your subcontract, but yet they're very important as you move through. If you don't submit a proposal or you don't meet certain deadlines, you could be breaching your teaming agreement, but that would simply not be actionable unless it was reduced to writing, because it would be one party's word against the other.
Right. And believe it or not, we've had litigation in the exclusivity provision. We've had clients who have agreed to be on multiple teams, and one team has gotten the award, and then later the losing party has moved to have the party that signed the multiple teaming agreements excluded from the work because they violated the exclusivity provision, and so all the more reason to pay particular attention to these sort of provisions on the front end.
So let's move to escrow accounts and ensuring prompt payment. So this is important to those of you out there who are in a subcontracting role. And it's an important concept to consider each and every time you sign a teaming agreement or a subcontract with your company as the subcontractor. We have run into many situations in the past handful of years where prime contractors have either gotten into some financial challenges or things have happened at the prime contractor level where they have not been paying their subcontractors on time. And if you're a small to mid-sized firm in a subcontracting role and your payments are not coming in a reasonable time, and if that happens to you on 2 or 3 subcontracts, you could certainly get yourself into a very, very bad financial condition. So use of an escrow agreement is a way to sort of prevent that from happening. What are they? So escrow agreements, I think everyone knows what they are. You take the money, you put it into the hands of a third party who is then responsible for administering the escrow account. They are useful because the money that is allocated among the prime and sub all lands in the escrow agent's hands at the same time, never touching the prime contractor, because what the escrow agent does is receives the funds, looks at the invoices, determines what funds go to the prime contractor and what go to the subcontractor, and distribute them out at exactly the same time. So the prime contractor is never tempted to use subcontracting funds to float their phone bill or any other payment challenges that they could be having. And this is something that contracting officers are familiar with. The act that governs this in federal contracting is called the Assignment of Claims Act. And there's a FAR clause, and if it's in there, the contracting officer can sign the documents along with the escrow agent, which is usually a financial institution, and then the payment is routed directly to the escrow agent. So it's a probably practice that's more common than you might think if you haven't heard of use of this, and it can really save you a lot of potential cash flow challenges down the road, and also avoid litigation, because many times the litigation that we see involves not being paid promptly enough.
That's exactly right. I certainly in the last few years we've seen since the period of the economic turndown that we saw many situations where, to use a hackneyed phrase, they were robbing Peter to pay Paul, and one of the parties was ending up on the short end of the stick. And frankly, we've even had litigation where the parties did not consider to do an escrow agreement on the front end, but then once litigation ensued for these payments, one of the remedies that we ended up settling on in mediation or alternative dispute resolution was the establishment of one of these funds so that the parties could drop the litigation. Once the parties had a reasonable assurance that the payments would be regulated going forward, then the litigation was dropped, and the parties continued to work together going forward with an escrow account set up. And believe me, Pam indicated there may be an expense in setting this up and maintaining it on the front end, but if you look at the big picture in the long run, the litigation expense that can be avoided by establishing one of them, it would be penny wise and pound foolish not to go ahead and set one of these up in the long run, because that may be the remedy that you end up with after having to sue to get your funds.
That's right, and I do think that it would be fair if you as the subcontractor are the one that's insisting on the escrow account, that you also offer to pay for that account, because it's not really something that the prime contractor needs, and maybe even under circumstances doesn't even want. Someone asked a question about privity of contract, and that's a great question, because obviously the subcontractor can't go to the government and ask for the escrow agreement to be established. That would be something that you would want to negotiate in your either at the teaming agreement level, but definitely at the subcontract level, and then your prime contractor takes that clause and goes to the government for the government to help to have it enforced. And then there's a couple of other questions that are leading to a couple other thoughts that I have. You know, we have in our subcontracts, oftentimes, if the prime is a smaller company, that payments due to the subcontractor within a certain amount of days of receipt of payment from the government to the subcontractor. Well, we had an interesting case last year, and it involved a prime contractor who was using a third-party financial institution, and so the government was making payment directly to that financial institution, not to the prime contractor himself, and so he argued that he didn't know when those payments were being made, and that, you know, it wasn't his responsibility. So, you know, it made me think that maybe those clauses could be buttoned up a little bit, because oftentimes if you're doing accounts receivable financing, the government isn't making the check out to the contractor. The government is paying it on the contractor's behalf to some third party, and probably making the check out still to an account that's in the prime contractor's name, but it's not necessarily going to the bank account. So something to think about there as well. And also, if you're negotiating something like this up front with the prime contractor, they may tell you that it's not possible for them to do because of obligations that they have based upon existing lines of credit. So if that comes up, I think that probably that's an area of discussion that maybe you can have with that prime contractor along with his banker, or, you know, looking at whether or not this particular contract can be carved out from any obligations that the contractor might already have with a financial institution. And if none of that works, then the business decision is, do I trust that this prime contractor is good to his word, that his, you know, business ethics are such that I'll get paid? What is his financial condition? What if he simply cannot pay? And what's my financial condition, and can I afford to take that risk?
Yeah, and so as Pam was mentioning, and so obviously do your homework. You may want to do some due diligence on the person that you are, and presumably you would do your due diligence, but you might want to investigate, to the extent you can, to the extent that such information is available publicly, the financial standing of the party with whom you're contracting, for any number of reasons, but especially if you're going to make the leap of faith that Pam suggested, that if you cannot negotiate an escrow payment, you certainly want to have done your homework on the front end so that you have a well-researched and solid fact-based reason to go ahead and exercise that trust that the payments will be coming through.
And we got one more question in terms of whether or not there's a FAR clause that requires the government to disclose whether it has paid the prime contractor in order to help the subcontractor to decide whether or not there's a late payment situation by the prime. And the answer is that the Congress passed a law 2 or 3 years ago, and this is now incorporated into the FAR, that says that for purposes of whether or not a prime contractor is paying its subcontractor on time, that there is privity of contract essentially, or the rule waives the lack of privity and allows the subcontractor to go directly to the government to ask whether or not the prime has been paid. However, the tricky part of that is that I believe that the clause as drafted and the law as drafted applies with respect to small businesses as subcontractors to large businesses, but not to other small businesses. So I think that there may be a gap in the law, and that no, technically you are not to go to the government and ask payment questions, and if you do, they may or may not tell you. Sorry, both of us are coughing today. Let's move on to our next area. Termination. So we talked briefly, given the case law, about the termination clauses that are in the teaming agreement, and we now know that our teaming agreements may be vulnerable because they have they're set up to have a lot of contingencies. This will terminate in a year. It may terminate if either company becomes suspended, debarred, etc. I mean, some of those are fine provisions that really need to remain in that teaming agreement, but we just have to consider them in light of whether or not we have an agreement to agree or a definitive agreement. But let's look at the subcontracts for a minute. What type of termination clauses do you put in your prime contracts that are flowed down to subcontracts, and when do you negotiate separate termination clauses outside of what's in the prime contract? And these may sound like very, very logical, simple questions, but I can't tell you the number of times that subcontractors have come to us and said, I'm not getting my work, I'm not getting a fair share of the work, the option was exercised or the task order was issued, and I don't think that, they're not coming to me and giving me any work. Well, oftentimes what happens is we say, let me see your documents. And so the first thing is that they'll tell you, I don't have a signed teaming agreement, or they'll send a teaming agreement that's only executed by one party, or we were too busy with startup on this contract and we didn't sign the subcontract. Well, you don't have anything if you don't have that in writing, except for he said, she said type of argument. Termination clauses are along those same lines. What did my contract say in terms of whether or not I can terminate someone for convenience? What are the grounds for a default termination? And should I simply use the government's flow down clauses? There's no right or wrong answer on that, but you should make sure that if you're flowing down the default provisions into a subcontract, that you also clearly outline the expectations for performance and for ongoing compliance with the ethics rules, with the limitations on subcontracting if they're applicable. Anything that you expect of that subcontractor should be defined in your subcontract. And then if they're not performing, not only just a performance issue, but an issue with a violation of the labor laws, for example, then you have a breach and you have a right to terminate for default. Likewise, termination for convenience. If you simply flow down the FAR clause, then your real remedy is that you terminate your subcontract for convenience if your prime contract terminates for convenience. But you may not have a prime contract that's terminated for convenience. The government may have done a partial termination of your contract or a downscoping to the point that makes your subcontractor irrelevant. So your termination for convenience clause should say something along the lines of, if the government descopes my contract and eliminates your portion of the work scope, then your contract can be terminated for convenience. So those are some of the ideas that we have with respect to what kinds of clauses should be put into subcontracts. Obviously, we protect you differently if you come to us as a prime contractor than if you come to us as a subcontractor. So each and every instance is really a matter of negotiation. And what are your strong points? What are your vulnerabilities? and then, reaching agreement somewhere in the middle. Well, we want to talk about, go ahead, yeah.
I'm sorry, I didn't mean to barge in. But
I wanted you to cover that.
To look at some questions. And with regard to the right to cure, as Pam just mentioned, the right to cure could be how you want to address a provision like that is clearly a matter of perspective. Are you a prime contractor who is being frustrated by a subcontractor who continually breaches, is not performing to the manner that you believe they're contractually obligated to do, that are exposing you to unnecessary efforts and costs? So you send a right to cure, the subcontractor gets their act together, cures it, and then 3 months later you're in the same situation again. The subcontractor leads you to the brink of breach and then cures the problem. So you have to think about what sort of effect the inclusion of a right to cure in your contract would have on your ability to have a smoothly operating performance of the overall contract. And of course that perspective is different. Obviously one party may very much want a right to cure because perhaps they've have an issue as to whether or not they performed, or they had some sort of issue arise over which they had no control that caused a problem with their performance, and they are able to get back on track. So that's a matter of perspective. Another issue that's not mentioned, and has been the subject of other discussions in our series, but with regard to the termination, once the termination is in effect, are you going to include a damage provision with regard to that termination that may include some sort of calculation of the damages, may address the issue of consequential damages, may address the issue of attorney's fees? Are you going to have a provision that says that in the event of termination and you have to pursue the other party for damages, are you going to be able to obtain your attorney's fees? So that's just a related provision that you might want to consider when you are crafting your termination clause. What are the damages that flow as a result of the termination, and what to whom would the fees be attributed if litigation or arbitration is ensued as a result of breach?
So, Paul, here's a good question. If you have a teaming agreement and you're in the role of a subcontractor and your team wins, but the prime contractor never provides you with a subcontract, what recourse do you have?
Well, I mean, if the teaming agreement, if you can convey that the teaming agreement is an enforceable contract, as we were discussing earlier under the CyberLock criteria, you may well be able to bring an action for specific performance. That is, this is a contract. This isn't an agreement to agree. This is an enforceable contract. They agreed to perform, and you go to court and you bring an action to compel the court to have them perform. But again, whether or not you're able to legally enforce, whether in a court of law, the terms of that teaming agreement will be contingent on whether or not it's enforceable or not. So, and that's the area we talked about earlier, but I would suggest specific performance. Compel or if they have agreed to, if the party has gone and contracted with someone else in violation of the teaming agreement, maybe you could seek an injunction from a court to prevent that from happening. Or another option is declaratory relief. Go to the court and say, here's a justiciable controversy. We have a disagreement as to what this provision holds. Court, you decide whether or not it's enforceable. So there's judicial remedies, but that would, whichever judicial remedy you wanted to utilize would be contingent on the case-by-case basis and what the actual teaming agreement stated. But you're not without a remedy is what I'm saying.
What about money damages?
Well, money, it depends. I mean, you could include a cost like that in your teaming agreement in the event of a breach, that the cost that, as a general rule, as you know, in teaming agreements, each party basically rolls the dice and spends the money to go forward towards the effort. You usually have provisions that say that they do so at their own expense. So usually that's money that is deemed to be part of the enterprise. But if the only problem with some of these damages issues with regard to contracts is that when you go into projecting what damages, what money you might have gotten had you been able to execute the contract, there are so many contingencies on that you get into an area of speculative damages. In other words, how do we know the government would have awarded this to this party? How do we know the government would have extended the contract beyond year X? So the more attenuated the damages get, the harder they are to prove with precision. So actual out-of-pocket damages, perhaps maybe the money you spent going forward on the teaming agreement. Maybe you've got an attorney's fee provision in there for the fees of enforcement. But as far as actual damages, the more they're keyed to what you are projecting in the future, the less likely you are to get them because they're speculative.
Okay, thanks. Period of performance clauses. I think we've touched on this a bit in connection with the termination, but you know, most of your contracts are a base period plus options. They also include language for modifications to the contract and extensions to the contract. So if you're the prime contractor and if you're the subcontractor, again, each party may have a different agenda, but what are the expectations? Do you expect your team to stay together throughout contract performance, the entire period of performance? If you do, you need to say that in your subcontract because, again, we have seen provisions where there's nothing in here. It's going to be the last 6 months of the contract or the last year, or we're going to be operating under extensions for a long time because the government can't get the solicitation on the street for the new work, and you may be competing with your subcontractor. So there's a legitimate business reason to not having them on performing. So we see that oftentimes that subcontractors are not protected in the subcontracting agreements and their last option year isn't exercised, or during one of the modifications or extensions to the contract in the final years, the subcontractor becomes unnecessary and is no longer a member of that team. So, you know, as a subcontractor, make sure you're protecting yourself, and as a prime contractor, you know, look at that and make sure that you've negotiated that provision. What about follow-on contracts? You know, we've seen maybe not as much lately, but in the past we have seen agreements where this team is planning to stay together for a follow-on contract. Sometimes we see that where the government will put out a small contract, but knowing full well that just around the corner is a big multiple award contract that is for task orders for a long period of time. And this team was really put together to go after the big contract, so they want to stay together for not only the small contract that comes first, but the follow-on contract. Again, that needs to be clear. And then a question again for enforcement. What if I'm not given my option as a subcontractor and I think I was entitled to it? Well, what evidence do you have that you were entitled to it? What does the subcontract say? And is there any extraneous evidence, such as what was in the proposal to the government? Did you price your subcontract for 4 years or 5 years, or did you just give a base year of pricing? So again, if it's unclear in the subcontract, you get to bring in that other information. If it's clear, though, then whatever the subcontract says will govern what a tribunal will say. Paul, do you want to talk a minute about arbitration versus mediation versus courts on this stuff?
Well, sure. And you may see some more detail in maybe one of our or two of our blog posts on this, but in including, it seems as every time I'm handed the microphone, it has to do with somebody arguing or fighting or a dispute, but that's I'm on the litigation side. And as Pam mentioned, one of the provisions you can include and should include, and no doubt do include in your form documents, are how do you intend to resolve disputes. And more and more disputes, it seems these days, are being resolved through alternative dispute resolution, ADR, which can be arbitration, mediation. But of course, as you all know, mediation is generally not binding. It's basically having a neutral third party get together and try to have the parties reach an agreement. Most subcontracts and agreements that we see, if they include a mediation provision, require mediation to be instituted at the first instance and then to go on to arbitration. My personal view is that if you're going to be not involving attorneys in this, and in as much as the mediation part is not going to end up in any sort of binding decision, you should consider whether that's a worthwhile enterprise. It's basically say, hey, let's get together in a room and see if we can agree. If you're at the point where you're considering going to court, one wonders whether that would be fruitful or not. But in any case, if there is an arbitration provision, the vast majority of documents that we see have a binding arbitration provision, and that means that the parties will either select an arbitrator or they will actually use some sort of mechanism provided by whether it's the American Arbitration Association, JAMS, or another sort of organization whereby the arbitrator will be selected. The general belief out there is that arbitration is quicker and less expensive. I personally am not so sure about that unless you provide in your document for some sort of expedited procedures. In my experience, arbitration can be as protracted sometimes as litigation, at least in Northern Virginia and in the Washington area, where this notion that you're going to file a suit and it's going to languish in the courts for years is really an archaic notion in today's times. I mean, that may be the case in certain courts around the country, but it's certainly not the case around here, particularly in the Eastern District of Virginia, which is known as the Rocket Docket. If you file a case in the Rocket Docket, it will be decided within 8 months, period. And I don't care if it's the most complex patent case you've ever seen or a simple breach of contract. They are going to move you through that courthouse. So some of the advantages of litigation are, too, as well, as if a judge makes a decision you don't like, then you can take it to a higher court for appeal, whereas most arbitrations provisions we see that even if an arbitrator makes a decision that is completely off the wall, you're pretty much stuck with it under the American Arbitration Act unless you put a provision in your agreement saying that the arbitration can then be taken to court for adjudication, which of course would be, in my view, an unnecessary extra step. So when you're preparing your documents, you need to consider what form of dispute resolution you want to exercise, taking into account the length of time for the resolution, whether you want a finality with an arbitrator or a judge that might be appealed, or and this goes hand in hand with your choice of law and your selection of jurisdiction. So it's really important to address on the front end and consider carefully what you think the most efficient and cost-effective way of resolving your dispute might be should you get at loggerheads with your contracting partner, so that you can expend as little amount of money as possible on folks like me and get to a resolution of the dispute efficiently and economically.
Will you say a word about choice of law versus jurisdiction?
Sure. Jurisdiction is more of an agreement. A jurisdiction is an agreement by you, and it's sometimes used inartfully in some of these documents. But basically, jurisdiction means the court that you select has the power to adjudicate the authority to adjudicate your issue. You may be dealing with a subcontractor from New Mexico, and you may be in Northern Virginia. The parties can agree that the jurisdiction and the venue for the dispute resolution will be in Northern Virginia. That saves you a trip to New Mexico, and it makes it you can select the forum that you believe will be most efficient for adjudicating your dispute. That should be a logical connection to the forum. But you've agreed that this court, irrespective of wherever we are from, this court is going to decide this dispute. The choice of law is a different question. You may want Maryland law to apply because you believe you're a Maryland company, or you believe that Maryland's blue pencil law would be more favorable to you, or you prefer Virginia law as it pertains to one aspect, or you might not like Virginia law because of the CyberLock decision and decide you want another state's law to apply. So you can choose the law that you wish to have applied to your agreement, and you can choose the jurisdiction in which you want the dispute to be resolved. And that's really something you ought to think about, because we've had clients that have not considered that, and they've ended up sending legal teams or having to retain counsel in Colorado or Texas or California because they didn't give much thought as to where the case will be adjudicated. And if you are silent on those provisions, then the court is going to decide that for you, and they're going to look to terms such as where was the work performed, where did the breach occur, where was the last act that ended up there being a binding contract occur. So if the work is being performed in Kalamazoo and the contract was signed in Kalamazoo, and you're a Northern Virginia or a Maryland contractor, you're out of luck if you haven't specified a local jurisdiction, because you may well be finding yourself going to Kalamazoo. Not that that would be a bad thing for you folks from out there, but what I'm saying is you may expose yourself to significant inconvenience, your staff to significant time away from work, and additional expense by not being specific about your choice of law and your jurisdiction.
I got a note that someone had lost audio. Could you please let us know if that's the case or if it's back on? It seems like it's fine. Okay. Thank you. Thank you, everyone. I want to say a word about representations and warranties, and these kind of take on a couple of different meanings. If you're in a commercial business or you're providing a commercial product to the government as part of your contract, then you will have representations and warranties as to the expected performance of the product and whether it's made to serve the purposes under the contract. Those are certain types of reps and warranties, and they're often called manufacturer's reps and warranties. What we're seeing more and more, though, are representations and warranties more along the lines of reps and certs that you're giving to the government. So if it's a small business set-aside or an SDVOSB set-aside, or if you need to, represent to the government that you haven't violated the Foreign Corrupt Practices Act for a job you're performing OCONUS and you have a subcontractor, you need to make sure that you flow down those provisions, if they're applicable, to your subcontractor, and that subcontractor certifies to you that he is in compliance. Now, you can make it even stronger than the certification by including specific language in the subcontract in the representations and warranties section. You want them to represent that they've read the FAR clauses that you've flown down, that they understand those FAR clauses, and that they are and will continue to be in compliance. And as I was looking at this slide, over the weekend, I was thinking about the new SBA regulations on limitations on subcontractors, because if those regulations become finalized as drafted, you as small businesses would be allowed to have similarly situated small businesses included in your calculation of whether or not you comply with the limitation on subcontracting. You would have to have small business teaming agreements. Those are the SBTAs referred to on the slide. Those agreements would need to be in writing. And at least under the current regulation, the proposed regulation, as drafted, your compliance would be calculated based upon the total amount of revenue that's divided between you as the prime SBTA and your sub as the SBTA, and the regulation carves out lower-tiered subcontracting as not counting toward the limitation. So if you have an SBTA with small business B, and small business B says, yes, I will perform 20% of the overall work of the prime contract, and SBTA B turns around and subcontracts 10% of that work out to a large business or someone who's not eligible, that is that's going to run you afoul of the limitation on subcontracting rule, which could lead to your certifications being inaccurate and quite frankly potentially false. Now, you had no intent to violate, but did your subcontractor, did you do enough due diligence at that point? And what did your subcontractor tell you? So again, all the more important to make sure that these things are put in writing, that they are given the stature that the federal government is giving them, and that these subcontractors know and understand what the expectations are of them, and that they could be, in serious trouble, because I believe that the entire team could go through some sort of a False Claims Act action if there was a violation that proved to be fairly egregious. So just a word about reps and warranties, but something really to consider as you're drafting.
Just that, only that.
This is litigation.
Yeah,
this
I'm
is
sorry.
yours.
I was just going to mention on that side is that even if your intent was benign, it may not make a difference, and it may not be a defense if you're not. It's not a specific intent statute. In other words, if you pass something through, and your intent, throwing your hands up and saying, "I didn't mean to do that," may not avail you in terms of the enforcement action. So this portion, we've talked a little bit about litigation. The breach of a rep or warranty could be the breach of the contract, can lead to contract termination, and we've talked a little bit about what possible remedies there are for the breach of contract. Again, if you're looking on the one side for enforcement of a contract, enforcement of a provision, you can look to the sort of the equitable side of the court, which is not really in the old days, the court was divided between law and equity. They're not really anymore. You go in the same door to get either. But on the equity side, you're looking at remedies such as injunctive relief, such as specific performance, such as those sorts of remedies are having the court do something that's fair to try to put the parties in the respective positions that they meant to be in when they were negotiating and bargaining. On the other side of the coin is in terms of the damages that you may be going for breach. So what remedy you're seeking will be driven by whatever the nature of the breach is, the breach of a rep or warranty, and whatever that misrepresentation or breach of warranty has led, whatever result that has led to will sort of guide the relief that you have. But it'll be determined on a case-by-case basis. Money damages, injunctive relief, again, depending on the facts of each case. But in the contract termination, even if you have an event that would constitute a breach of contract, you may it does not necessarily mean you want to enforce that breach. I mean, you may want to continue the relationship and undertake some sort of curative steps that would avoid that in the future. So, again, need to be determined on a case-by-case basis of the effects of the breach of the rep or warranty, what damages, if any, and whether or not you want to preserve the relationship will guide that decision.
So use of flow down provisions, I think we have covered this, but again, you want to make sure that you look at them if you're drafting the prime contract, if you're drafting the subcontract as the prime, determine which ones are applicable. Don't just do a data dump of everything in the prime contract and flow it all down, because then that would show that maybe there was really not much thought put into what the terms were in this subcontract. So weed through them. Look at the ones that are applicable. Anything that could be, problematic if it wasn't enforceable at the subcontract level, you need to flow it down. And then again, you could validate that your subcontractor read these and understands them by putting a representation in the body of the subcontract that said that they've read these and they intend to comply.
One of the things I'm struck by with many of the things that Pam has said throughout this process are that the attention that needs to be paid to each and every one of these elements. We oftentimes see folks that utilize essentially form cookie-cutter documents that include these sort of flow-down provisions without having, as Pam directed and advised, consideration as to the facts of each relationship. In other words, don't take, it's not a one-size-fits-all. When you have these subcontracts, take the time to analyze the nature of the relationship, the nature of the duties and the tasks, the contract, what's going to be performed, and either include some of these flow-down provisions or don't include them. Just simply don't apply your boilerplate contract to each factual situation, because in our experience, at the end of the day, you may live to regret that decision, because you find that you've actually flowed down provisions that you didn't necessarily want there, or you've omitted to consider other options by using your cookie-cutter document.
So I think we have another minute or so, Paul, and I have two questions that I don't think we answered. One question is, hold on one second if I can find it. Oh, a good source to do your due diligence on a small business and their financial condition. And I think that's a good question. If you can pull a Dun & Bradstreet on a company, they may or may not be, good. They're kind of as good as what information is given to Dun & Bradstreet. You could look in the databases to determine what contracts they have. You can also, and this is kind of, a little bit more touchy, but you could also ask them for their financials. Now, it's likely they won't want to give them to you, but they may give them to your CPA. And your CPA can agree not to discuss them with you except to give you a thumbs up or thumbs down. And your CPA would probably be willing to sign an NDA in order to look at those financials to give you some clue as to the viability of this company. And if it's not good, then you make a bid, no bid decision, or you decide to insist on that escrow agreement. And then the last question, it looks like, if I'm understanding it, is that there was not a written subcontract, but the parties are performing, and so if there's a dispute, what happens? And in that case, it would be for Paul to answer.
Well, I mean, in that situation, when the parties don't have a written contract, then you've got certainly an implied contract, and the court is going to look to the extraneous factors that we've talked about earlier, and will essentially, there's a contract implied in law, and so what are the terms of that contract? That's when the court would look to, in the absence of written agreement, what were the parties' expectations? What does the earlier correspondence indicate that the parties intended to do? What did they actually do? And basically compile all those elements, and it's a legal fiction, but the court will come up with its determination of what the parties contracted to based on their expectations, their communications, their actual performance, and the court will apply a contract of law.
And so under that circumstance, you could be entitled to money damages.
Absolutely.
Okay. That's all the time we have. Thank you so much for listening in. I hope that you found this to be useful. And if you have any other questions, our email addresses, I think, are on the slides. Don't hesitate to email either of us. Thank you.